One of the most important distinguishing features of European company law consists in the general availability of the information on companies incorporated according to the laws of one of the member states. In fact, European law requires limited liability companies to publish in business registers a wide set of documents and particulars. Although the level of harmonization imposed by EU law in this field is remarkable, many differences still exist between member states with regard to the precise content and format of business register certificates. In fact, until recently, the information on companies was made available by business registers only in the member state where each company was incorporated, and if a company wanted to operate in another member state, it was advisable to create a branch in that member state, among other things, also to acknowledge the presence of that company in the business register of the foreign member state. However, more recently, the European institutions promoted the creation of a business register interconnection system, the so-called BRIS, which aims at making available companies' information across borders. The creation of an interconnection system between national business registers raises new issues on the interpretation of the information on companies, which now becomes available across borders. For example, while the content of the information to be disclosed is largely harmonized, there is still little harmonization on what should be the legal value of the information made available by business registers. More precisely, in the member states where the information filed with business registers is subject to preventive controls by public authorities like notaries, the published information normally has a stronger legal value than in countries where filings are not subject to such preventive controls. In a word, the former are essentially registers of verified information, while the latter are just registers of unverified notifications. Furthermore, as also the European Commission recently acknowledged, the mere cross-border availability of information and documents via the system of interconnection of business registers has no implications on the need to receive certified and apostille documents, where these formalities are required by the law of the member states where these documents should be used. Therefore, in this evolving technological and legal framework, in which the information stored in business registers may be accessed across borders, it becomes essential to correctly interpret the legal value of the documents and particulars that are made available. So, it also becomes fundamental to ask the advice of legal professionals like notaries, who have a vast knowledge of the details of the national laws governing the legal value of the disclosure of company information.